In this video, I'm going to take a look at a recent case, October 2018, where the Court of Appeal clarified the situation in relation to the legal right to representation in disciplinary proceedings in the workplace. This is something that comes up from time to time when an employee is involved in disciplinary proceedings. Sometimes he or she wants to bring in lawyers. Has he or she got a legal entitlement to, and so on. This is an important case. It involves a Court of Appeal decision from October of 2018 involving Road or Irish Rail against a gentleman called Barry McKelvey. In this case, Mr. McKelvey was an Irish Rail inspector. He was subjected to a disciplinary procedure in the workplace. There was an allegation of misuse of company issued fuel cards and alleged theft of fuel, and this led to significant financial loss for the employer. Mr. McKelvey was denied the right to have legal representation at the disciplinary hearing, and he then went to the High Court about the issue and he sought to have the disciplinary hearing halted. Mr. McKelvey was successful. The High Court application was founded on three main planks, as it were. One, the reputational impact on his good name and reputation. Two, the complexity of the case. And three, the issues of law arising in the disciplinary proceedings. The High Court agreed and they halted the disciplinary. The company then, Road appealed this decision to the Court of Appeal. The Court of Appeal agreed with the High Court in relation to the factors to be considered, but they decided that the High Court had misapplied the factors to the circumstances of this particular case. The legal representation, according to the Court of Appeal, should only be granted in the most exceptional of circumstances. The Court of Appeal also held that natural justice and fair procedures could be applied without the need for a lawyer, and the help of an experienced trade union representative was sufficient. And in this case, that was the position for Mr. McKelvey. He had trade union representation. He was arguing, obviously, that that wasn't enough and that he was entitled to a solicitor. The Court of Appeal also clarified or made the point that workplace disciplinary investigations and hearings should not be directly compared with investigations and hearings carried out by professional regulatory bodies such as the Medical Council or other professional regulatory bodies. This would include, for example, the Law Society. The Court of Appeal, however, did not clarify definitively the question of the right to cross-examine witnesses in a disciplinary hearing, because Irish Rail had allowed this to Mr. McKelvey as part of its procedure, and the question then did not have to be addressed by the Court of Appeal. The advice for employers: it's advisable in any event, however, that the right to cross-examine witnesses should be afforded to employees involved in a disciplinary hearing, even though there appears to remain a difference of opinion amongst lawyers on this point. The Court of Appeal also left the door open to reapply for Mr. McKelvey if a complex issue of law arose in the process. You can read the full decision in this case on my website, employmentrightsireland.com. Now, there's actually, I've written an article about it. If you just do a search on the website for Road or McKelvey or Court of Appeal Clarifies or something like that, you'll find the article, and at the very, very end of the blog post there's a link to the actual official decision from the Court of Appeal which is on the court's website, but the link is on my website. I hope you find this video useful. My contact details are on the screen. If you do, give us a thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you are, just hit the subscribe button and you'll be notified when I bring out a new video, and I bring out new videos twice a week on a Wednesday and Saturday.